Hello everyone, this is Jennifer. In this video, we're going to look into the features of Competition Act 2002. So these are the various features of Competition Act. The first one is prevent practices having adverse effects on the competition. So Competition Act basically came into existence why? To have a healthy competition and to basically demolish or eliminate the monopoly system in the market. So it basically prevents its practices having adverse effects on competitions. That is the first feature. Second one, it curtails its abuses of dominance to give effect to the second generation economic reforms on the pattern of the global standards set by the more developed countries. So it basically reduces the dominance which are uh, enforced by the developed countries on the developing countries based on competition. Third one is promote healthy and sustained competition in the market. The fourth one is ensure quality of products and services. So obviously when we look into competition, our main concern is looking into our customer satisfaction. So one of the main features of this act is to ensure providing quality products to the customers and services. Next is protect the interest of the customers by giving quality products at minimum prices and not cheating them. The next point is ensure freedom of trade carried on by other participants in the domestic market. Next is facilitate mergers and acquisitions of companies with providing freedom of trade or freedom of entry and exist. So the next one is basically this act is enacted to provide or to keep in mind uh, the economic development of country by reducing or eliminating the unfair trade practices which was followed earlier. So these are the various features of Competition Act. So now we look into the salient features of the act, which are basically divided into four categories. The first one is a prohibition of anti-competitive agreements. Second is prohibition of abuse of dominant position. Third one is regulation of combinations. The fourth one is establishment of the Competition Commission of India. So we'll look into point by point. The first point is prohibition of anti-competitive agreements. The first one is anti-competitive agreement. So anti-competitive agreements are being prohibited under this particular law. Why is it? Because it is not lawful for any enterprise or association of enterprises or persons or association of persons to enter into any agreement in respect of production, supply, storage, distribution, acquisition or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India. So all such agreements will be considered to be void, and section 3 of the act specify the activities which are presumed to have an adverse effect on the competition, like the purchase or sales or the or bidding, rigging, etc. activities which will have a will have an effect on the competition will completely be eliminated or prohibited. And non-application of section 3. So section 3 non-application does not basically apply to the right of any person to restrain any infringement or the copyright activity which happens under the Copyright Act, or the patent activity which happens under the Patent Act, or design activity which happens under Design Act, or the layout activity which happens under the Layout Act. All this will not be pictured under the section 3 of the act. Why? Because this section 3 basically talks about whatever activities which will have an effect on the competition, which completely will be prohibited according to the Competitive Act. So moving on to the next point, prohibition of abuse of dominant position. So under that, section 4 of the act prohibits abuse of dominant position by any enterprise. So no enterprise shall abuse its dominant position. So no taking up of dominant position over the other participant in the market, because that has been completely leading to unhealthy competition. So what kind of dominant position are we talking about? Is limiting or restricting participants, making the contracts very uh, commercial use, which has no connection of societal use, or indulging in practices or practices resulting in denial of market access, or using your dominant position in one relevant market to enter into another relevant market. So abuse of dominant position by an enterprise is always been prohibited under the act. So third one is regulation of combinations. So the various provisions relating to the regulation of competition are: the Competition Act 2002 regulates combination of enterprise and person. As per the section 5 of the act, acquisition of one or more enterprises by one or more persons, or acquiring of control of merger or amalgamation of enterprise under certain circumstances shall not be construed as combination of such enterprise and persons, or enterprise if certain conditions are fulfilled. So basically combining of 1 or 2% and taking control over the So amalgamation of one or two companies, or acquiring of control or mergers will happen only if there are certain conditions which are fulfilled. The first one is acquisition of control, sharing of votes or assets. So the parties to the acquisition being the acquirer and the enterprise whose control or shares or voting rights or assets have been acquired should jointly have, either in India, the assets of the value of more than 1,000 crores, or turnover of more than 3,000 crores. In India or outside India, in aggregate to the value of the assets more than 500 million US dollars, or turnover of more than 1,500 million US dollars. Or if this is not fulfilled, the next condition is any group or an enterprise belonging to such group whose control shares, voting rights or assets have been acquired jointly should have, either in India, the asset of the value of more than 4,000 crores, or turnover of more than 12,000 crores. Or the point B is in India or outside India, in aggregate the assets of the value of more than 2 billion US dollars, or turnover or more than 6 billion US dollars. So this, only if they fulfill these conditions, they will have they can basically fulfill the condition of acquisition of control, shares, voting rights or assets. The second one is acquisition of control over production, distribution or trading. So the under this, the condition is, the first one is either in India the asset of the value of more than rupees 1,000 crores, or turnover of more than rupees 3,000 crores. Or in India, if it is combination of India and outside India, then it should be more than 500 million US dollars. So the group on which the enterprise whose control has been acquired or being acquired would belong after the acquisition jointly should have more than 4,000 crores in India worth, or if it is India or outside, it should have more than 2 billion US dollars. So mergers and acquisitions, any mergers and acquisition will be a combination if only when the enterprise remaining after the mergers, or the enterprise created as a result of the amalgamation, as a case may be, have either in India the assets of the value of more than 1,000 crores, or turnover of more than 3,000 crores, or in India or outside in aggregate the assets of the value of more than 5,000 million US dollars, or the turnover should be more than 1,500 million US dollars. So basically when they fulfill these conditions itself, they can get into mergers and acquisitions. So this is being regulated by the Competition Act. So the last point is Competition Commission of India. So the Competition Commission of India is a body which have a perpetual succession and a common seal with power to acquire, hold and dispose of property which is both movable and immovable, and the contract shall be named to be sued and to sue another party. The head office of the Competition Commission is placed as a central government may decide from time to time, and the composition of the Competition Commission is consist of a chairperson and not less than 2 or more than 10 members to be appointed by the central government. So what is the features of the Competition Commission of India is entry into certain agreements and dominant position of the enterprise. So it basically looks into the agreements and the dominant position of the enterprise. Second one, consideration of factors which basically cause adverse effects on the competition, like the creation of barriers of new entrants, driving existing competitors, etc. The third point is inquiring whether an enterprise enjoys the dominant position. In respect to the market share of the enterprise, the size and resources of the enterprise, the size and importance of the enterprise, the economic power of the enterprise, the vertical integration, the monopolistic system, the market structure, the size of the market, and the cost involved in the making the market a much more competitive market. So moving on to our next point, which is CAT. So what do you mean by CAT is it is a competition appellate tribunal. So it is a quasi judicial body constituted under the Competition Act, and it is headed by a chairperson who will be serving or the retired judge of the Supreme Court of India, or he can be serving or be retired Chief Justice of the High Court, or he can also be the qualified to be the judge of the Supreme Court or Chief Justice of the High Court. And the members of this particular association is an eminent person from socio-economic fields, and it appeals under the against the orders of the Competition Commission of India. And basically this was formed to check the anti-competitive practices, that is your anti-competitive agreements, to prohibit abuse of dominance, and to regulate your combination, and to provide for the establishment of CCI, which I basically told about it in the previous 4 slides. So those 4 features, this is what is it been so that is being monitored by the Competition Act. Along with that, this also will be monitoring it. So powers and obligations of the CAT is it is not bounded by the procedure laid down in the court of law, but it shall be guided by the principles of justice. So it is basically developed for the purpose of discharging its functions under the Act with the same powers, and every order made by the penal tribunal should be enforced in the same manner. How basically will they appeal in the court of law is every appeal shall be filed within a period of 60 days from the date on which a copy of the direction or decision or order made by the Competition Commission of India is received, and it shall be in the prescribed form and shall be accompanied by the prescribed fees. So it's just like a court. Okay, so moving on to our last topic under this particular act, which is offenses and penalties under the act. So, penalty of contravention of orders of the Competition Act. So, what is the penalty for that is, so if they have done anything like that, the penalty, he shall be liable to be detained in civil prison for a term which may be extended to 1 year, unless in the meantime the commission also directs his release, and he shall also be liable to penalty not exceeding rupees 10 lakhs. So why, when does this penalty will be uh, imposed on him? It is when if a person contravenes without any reason, ground, an order of the commission or any condition or restriction subject to which approval, sanction, direction or exemption in relation to any matter has been accorded. So the second penalty is, if the commission is making any order under this act and issues direction to any person, if it is not inconsistent with this act, it is necessary for the proper implementation or execution of the order. And if any person who commits to breach the order, then he is liable to pay penalty not exceeding rupees 10 lakhs, and he will be detained in civil prison for a term not exceeding 1 year. So the second penalty is penalty for failure to comply with the direction of the commission or director general. So the penalty imposed is rupees 1 lakh for each day during which the failure continues. And for the third one, penalty for making false statements or omissions to furnish material information. So at that time he shall be liable to a penalty which shall not be less than rupees 50 lakhs, but which may extend to rupees 1 crore as may be determined by the commission. Point number 4, penalty for offences in relation to furnishing of information. So in this, the penalty may extend to rupees 10 lakhs. The commission may also pass such order depending on the furnishment of information or the destruction, how it is being done. Point number 5, power to impose lesser penalty. So the lesser penalty shall be imposed by the commission only in respect of a producer, seller, distributor, trader or service provider included in the cartel who first made the full, true and vital disclosure under this section. So only if the commission is satisfied, they can provide a lesser penalty, and it shall also be liable to the imposition of penalty to the person who has been liable to receive the lesser penalty, or the lesser penalty to not be imposed. So it is only for the producer, seller, distributor, trader or the service provider. The next point is crediting sums realized by ways of penalties to the Consolidated Fund of India. So section 47 of the act provides that all sums realized by the way of penalty under this act shall be credited, where it shall be given it to the Consolidated Fund of India. The last point is contravention by companies. So according to the section 48 of this act, where a person committing contravention of any provisions of the act, rule, regulation, direction, order made thereunder is a company, every person who at the time of contravention was committed was in charge or was responsible for the company for the conduct of the business of the company shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. So these are the various offences and penalties against the under this act which the act provides. So thereby we finish up with the Competition Act. So these are the various topics. So thank you everyone.